Hi, Namrita. Thank you for agreeing to do this interview. Before we get started with the questions, can you just tell me a bit about yourself, a brief profile about yourself?
Hi, Shrishti. Sure. Well, I'm Namrita, and I have more than 16 years of experience, and I'm currently working with Dheer and Dheer Associates as a partner, and I co-head the corporate practice within the firm, and my specialization includes labor. I do a lot of labor and employment work. I do a lot of contracts, general corporate commercial transactions. I do private equity, and I have done a lot of defense procurement related work. I have done TMT, which is technology, media, and IT. You name it, and I've done it. It's more like that.
Great, thank you so much. So I'm going to be asking you questions on labor law and employment. I know
Sure.
that you're well versed in that as well. So just my first question is it mandatory for employees to work from home during the lockdown period?
Well, just to give you a quick background, so before we begin this Q&A, I wanted to share my view that there are so many contradictory views available on the internet, and since this has happened for the first time, and there are no precedents, we must not take very stringent view about a lot of things. And ultimately, the scope, applicability, and interpretation of the Ministry of Home Affairs orders, as well as Labour and Employment Ministry's advisory, followed up by state-specific advisories, will be interpreted by the court, ultimately on a case-to-case basis. So these are our views. Yeah, these are our views. And sorry, please go ahead.
I'm sorry, I'm just saying that I understand what you're trying to say. So maybe we can just get your perspective on it. Like, where is it likely to go, right? So we can answer the question from your perspective rather than from a clear black and white, because I understand there's a gray area as well, right? So do you think is it mandatory for employees to work from home, or is it more like a paid leave situation? Like, where does the law stand on this right now?
So see, no, it is not mandatory for employees to work from home, especially just to give you a quick background, that Ministry of Home Affairs issued its order on March 24th, and basically it issued directions to state governments and UTs to impose the lockdown restriction. And they came up with guidelines that those were annexed with the order, basically said that apart from the identified establishments, private and commercial establishment will remain closed. And those establishments are basically the ones which are providing essential goods or essential services. Industries which are into manufacturing essential goods or services, those have been permitted to remain open during the lockdown restriction. And so therefore the employees working in or the staff per se working within those organizations have been exempted. Now it also includes IT to some extent, IT and ITS companies, and unfortunately the language is very ambiguous, but if you kind of look into it, so you understand that IT and ITS services which are providing support or ancillary services to essential services such as bank. For example, just the bank or hospitals, creating data, collecting data, and all those IT, ITS enabled services, those have been exempted too. So the staff and employees or workers in those specific establishments have been exempted. Now, post that, on April 15th, Ministry of Home Affairs again reissued orders. There were several addendums as well to include certain additional services. But then on 15th April, they came up with revised consolidated guidelines, which included certain other establishments. The staff, whoever is working in those establishments, have been exempted. And they can work from home. Of course, for other private and commercial establishments which continue to remain closed, their staff and employees have to work from home.
Okay. So, but if in case the employees are unable to work from home, because there are lots of jobs and kind of employments where you need to be physically present to actually do the job. So in case they don't, if they are unable to work from home due to the nature of the job, then do they need to actually be paid wages or salaries for this period? Is it mandatory?
Yes. Again, just to give you another example, Ministry of Labor and Employment came up with this notification. Actually, what happened that when Ministry of Labor and Employment came up with this notification, it was more like an advisory. It was not issued under any statute per se. And it basically said that, I'm just going to stick to the key points. It said if the employer's establishment is closed during the lockdown and has become non-operational because of the lockdown situation, then in such situation, the employees will be deemed to be on duty. So it's a deeming provision.
Okay.
And employer is also under an obligation under that advisory. I mean, it's not really, again, a lot of people are interpreting it as an advisory, saying that, oh, it's just an advisory. It's not been issued under any statute. Mm-hmm. So it also says that they have to pay full salary and wages without any deduction. Okay. And if employees are taking any kind of leave, they will again be paid full wages for that. Now, since it was not issued under any statute, my view is that Ministry of Home Affairs came up with that order. Now, the order does not talk about termination as advised in the Labor and Employment Ministry's notification. It says that you cannot even terminate employees. But Ministry of Home Affairs orders only specifically stick to giving wages to workers, be it any industry or shops and establishment. Now, unfortunately, for many employers, they are very confused. They do not understand how to actually interpret it, because our labor law legislations identify. So there are different categories under labor laws. So one category is, so ID Act, which is the main act, recognizes two categories, which basically says workmen or non-workmen. So we don't know whether white-collared employees are included in it or not, which means that people who are working in managerial supervisory capacity, earning more than 10,000 rupees, are whether they are specifically included in it, or whether whether an employer has to pay wages only to workers who fall under the category of workmen. But as of date, as we stand, the MHA's order has been issued under a specific statute, which is Disaster Management Act and Epidemic Diseases. So therefore, keeping that in mind, it holds good. And employers, by way of abundant caution, it is advised, it is recommended that during the lockdown period, post that they may kind of enter into some kind of negotiation with either trade unions or with labor or workforce. But during the lockdown period, they have to pay full wages.
But where does this leave companies that are suffering from a severe cash crunch? Suppose, a lot of companies are facing like severe revenue losses, and because of that, they're having a severe cash crunch. Like, are they not allowed to like lay off employees, or are they not allowed to like negotiate reduction in rent, reduction in salaries when they're just not in a position to pay, or they're not sure about the viability of the business model at all going forward? I mean, there is that possibility as well.
Well, as far as Ministry of Labor and Employment's notification is concerned, it is more like an advisory. Certain states have issued similar advisories, such as state of Haryana has issued similar advisory. But there are certain states which have issued orders as well. So the states which have issued simple advisory or advisory not to terminate or retrench anyone during the lockdown period, those employees may kind of get into the, may think of laying off or retrenching or terminating employees. However, they must keep in mind that if a consent can be obtained or procured from the employees, or they can enter into a discussion per se, because so far there are a lot of employers who had initially issued that there were a lot of news articles that said, we're going to lay off employees, we're going to terminate employees because we can't, there are no revenue streams, there's no revenue generation, and we are kind of stuck with this financial crisis and we don't know what to do. But most of them are, they have not taken any action in light of these advisory, because a lot of people don't know how to interpret it. They don't want a situation where it boomerangs. So there is no prohibition. They have to follow the provision of law. Especially when it comes to workmen, they will have to follow the provision of Industrial Dispute Act. And as far as terminating employees who are in supervisory or managerial committee capacity, you have to actually look into the terms of the employment. What do they say? Even some employment contracts have force majeure clause, where parties are excused from fulfilling their obligations. So they'll have to kind of assess it very carefully. Whatever termination letters that will be prepared will have to be very carefully worded. So one has to keep a lot of things in mind, and we as of date, as we stand, I again lay a lot of emphasis on one thing, that we don't know how this advisory would be interpreted. But yes, there is no prohibition per se.
Okay, thank you.
Actually, sorry, but just one bit also I wanted to kind of say that, Section 72 of DMA Act has an overriding effect. So even if Industrial Dispute Act or employee standing orders provide for natural catastrophe or a natural calamity, our law recognize these kind of situations. They also recognize now something beyond the control of employer. So they kind of recognize these situations, eventualities. But given the fact that DMA has an overriding effect, whether the employers can actually go ahead and take these measures or actions in the current financial crisis or whatever financial crisis that they're facing, it'll be again it may have some negative impact.
Namrata, are there any obligations on employers to inform either the authorities or the employees in case there are any COVID positive cases in their organization?
Well, there is no mandatory provision, or there is no obligation so far imposed on employer to actually or makes it obligatory for employees to actually report COVID-19 case to any authority. However, having said that, I personally feel that as a good corporate practice, if you do come across any information which says or suggests that any one of your employer is suffering from COVID-19, you may suggest that employee to report it to the authority, or may actually consider reporting it to the authority. So there are numbers, helplines issued by Ministry of Health, and you can either send a mail or you can actually call them up and let them know. But there is no mandatory provision as such.
Okay, fair enough. My next question is, can an employer make it mandatory on an employee to get certain tests before they come to an office? Can this be a mandatory?
Oh, it's a very interesting question. I have been getting a lot of these questions these days. I've been working extensively on a lot of labor and employment queries for our clients. In fact, I've recently submitted a note to one of our major clients on labor and employment issues, as they employ more than 1,000 employees, and which include workman category, non-workman category, and also fixed-term employee contractual labor. So we've kind of evaluated the whole situation, and I've very recently submitted a note. And one of the questions was this. So a lot of employers these days, and especially multinational corporations, since they have these global policy to ensure that whenever they're hiring any employee, or they suspect any employee of having any disease, or any employees coming after a long sickness break, they have these company policies in place that they may ask such employee to get the fitness certificate. So sometimes most of the organization pay for it. They pay the employee and direct the employee to undergo certain tests, and they take the report and put it in their employee file. So that's a normal protocol, and most companies are following that. So now, yes, if supposedly, in a situation where you suspect that any employee has had COVID-19 or is showing symptoms of COVID-19, you can actually direct that person to get the medical test done. There is, as part of, again, you'll have to look at your company policy, employee policy, whether or not the same was agreed in the offer letter, because most of the offer letters usually have this clause which says that you will submit your medical records before you join the services, and even during your employment we may direct you to undergo the medical test. So yes, you can direct. You'll have to look at the company policies. If not, you can, if anybody is suffering from COVID-19, you in any case have valid reasons. So just to give you a very quick example, so state of Karnataka, in fact, has directed employers to give 28 sickness leave if in case any employee is tested positive for COVID-19. Now, employee has to get a certificate from the ESIC authorities and submit it to the employers. And that to avail the leaves. So in any case, the moment supposedly I'm an employer in state of Karnataka and any employee of mine is been tested COVID-19, he would just simply come to avail those leaves. They will have to procure the certificate. The moment I get the certificate, I in any case have a record of that employee. And I can ask that particular employee, I can track and direct that employee to get the medical test done again.
Okay, fair enough. So I have another question, a related question. Does medical tests qualify as sensitive personal data under Indian law? And are there any obligations on employers, on collecting such data? Are there any data privacy laws regarding
that? So, in the current scenario where we are all working from home, I'm working from home. There are a lot of other employees in many industries that are working from home. So we are in a situation where I cannot come and physically submit my medical data or record to Srishti as my employer. So what I'm going to do is I'm going to send it by email in all likelihood. So in such case, any medical history or data, which is in electronic form, will qualify as sensitive private data under the SPDI rules, very popularly under Information Technology Act. So Information Technology Act has a list of certain items which actually qualify those items as sensitive data or private data, and imposes an obligation on the employer to keep it private. Now, when you are, that includes medical history and record. So employer in any case is under an obligation. So once you procure, so if I'm an employee, I'm sending my medical history or data, my employer will be under an obligation to keep it. So it will qualify as under the sensitive data as under the SPDI rules. So it will have to be kept confidential. There are other obligations such as employer will have to seek consent, a prior consent. So if I am supposedly, my employer is sharing that medical history or data with the authorities, it is better to take prior consent, because I think if I'm not wrong, Rule 3 provides for the definition of what qualifies as sensitive data, and there are certain obligations imposed under the rules for employer to seek consent, and only if it is necessary, then only collect the data. Now, having said that, currently, as we stand with coronavirus being identified as pandemic and epidemic, so it is a valid reason for any employer to collect the data to ensure that per se, if the lockdown restrictions are lifted and we go full throttle with again joining our office and working from office, it's important to ensure that employees who have had COVID-19 or who tested COVID-19 or who are showing symptoms of COVID-19 are kept away from the office. So, but yes, employers have to will have to follow the obligations set forth in the SPDI rules.
Okay, fair enough. Really appreciate you answering our questions, which are very relevant in today's times. Thank you so much for doing this.